Good evening, call-out participants. This is round one of our most recent debate qualifier, and whomever wins this arm of the tournament will get a bye into the $5,000 end of summer debate tournament. The prospect on the table, I am on the agree side, and Mr. Switchler is on the disagree side. Lie detectors should be used to support the legal process in court. For purposes of this debate, I'm going to assume that the term lie detector is referring to the traditional polygraph test, which is a test that measures physiological responses in order to test for the veracity of the person taking the test. If Switchler desires to bring in other forms of lie detection, I have no objection to that because I believe that my points will remain the same. I'm not totally sure what country you're in, Mr. Switchler. Something makes me think it's Australia. You may be here in America. Okay, in Australia. So two common law jurisdictions here. You've got the American legal system and then the Australian legal system, both born out of the common law system. We're going to have similar legal concerns. So the base of my argument is as follows. With very rare exceptions in the jury-based legal systems that our countries share, both for criminal and civil dispute deciding, the presumption is you bring in as much evidence as you can and let the fact finder sort it out, whether the fact finder is a jury, whether the parties consent to that being a judge. There are a very limited number of categories of evidence that we categorically exclude, period. I do not believe that the polygraph should fall under this exception. Tonight we'll be talking a lot about forensics in general in the legal process. So a key premise of mine is that whatever its faults, whatever its strengths or weaknesses, the polygraph is not sufficiently distinguishable from any other form of ordinary science that is admitted into courts on an everyday basis, or even distinguishable from any sort of non-expert evidence that is admitted into courts on an everyday basis, that it should be put on whatever kind of reverse pedestal you would call it to be automatically excluded from court. I'm going to address both the issues of the use of the polygraph in the criminal setting as well as the civil setting, the limitations thereof, and then I'll address any specific concerns that Switchler has. Again, I am defending the proposition lie detectors should be used to support the legal process in court, and I will now pass the mic over to Switchler for his opening remarks.
Certainly, and thank you very much for that introduction. So you mentioned this idea that there needs to be, that it's not indistinguishable from any other kind of science in terms of forensics and things that we already allow into court. I have two main premises of the argument that I'm going to have today. The first is a kind of like practical concern that exists with the polygraph test. And I think you laid out the scope of this debate quite reasonably. We'll talk specifically about the polygraph. Is insofar as that the polygraph itself is a unreliable piece of pseudoscience that is inherently very misleading, and that through nearly a century of misinformation being spread by sort of just public knowledge of how these things work, means that people get very inaccurate ideas of what it's actually showing up. And I think that probably is grounds enough for itself about why it should be discarded from any kind of legal process. The second sort of principled idea that I might talk about is that even if we could assume that what it is showing is some degree of accuracy, that is based on basically just confirming people's own sort of eyewitness testimony and experiences, which in itself is also something that is heavily unreliable. And that is something that we should probably be looking away from in terms of trying to determine guilt. And that we should be, using more reliable sources like the forensic evidence that you have brought up earlier. So just as a quick introduction to the idea of the polygraph being an unreliable, there's been no scientific claim that has ever been able to link the use of the polygraph test to any sort of way to actually determine that someone is lying or not. So the person who invented it himself later went on to regret how it was being used, insofar as that people were making all these claims, and particularly law enforcement was making all these claims about that it could be used to detect truth, which was something that was never intended for its use in the first place. It was simply something that was, as you said, measured stuff like heartbeat, amount of sweatiness that a person has, like a number of other physiological factors. The problem is that there's no concrete link between any of those physiological factors and someone actually lying. Like, it's very, very easy to pass a polygraph test by just staying like very calm and remaining very, easy within the bounds of when you're answering the questions. And really what it more accurately measures is just how nervous the person are, which is a dangerous thing to do in court, because you would have to assume that a number of people who are giving testament in court probably would be in a pretty nervous situation, which means the readouts that it's going to get are likely very inaccurate. So as the first basis for my argument, I would say that anything that provides a piece of evidence that is different from what the expectation is, insofar as that if you get a printout of a polygraph that is going to be presented to the jury as saying this is proof that someone is lying, when in fact it is absolutely not proof of that at all, that should be grounds to remove it from the legal system.
Okay. Well, let's start with the term pseudoscience, because that's a useful place to start. You have said that people get an inaccurate idea of what the polygraph does and does not show based upon pop culture. This, unfortunately, in this day and age, is true of nearly every form of science, both legitimate and otherwise. Now, there's a very good parallel to be drawn here. You note that there's no specific link between physiological factor A and truth or falsehood in what a person is saying. And that's true. In fact, even in states that certify polyographers, what a person is certified on is their ability to make judgment calls. So an individual polyographer is not looking for one specific physiological factor. They're taking a totality of what they know about how the machine works, how human psychology works, observing the suspect, or just the regular witness. We don't want to get too pigeonholed into the criminal defense context. But they are giving an opinion that is based on their interpretation of numerous facts. There is a very useful parallel here in fingerprint evidence. There is likewise in popular culture this idea that everyone has a unique fingerprint, and therefore fingerprint evidence is very strong evidence that a certain person has touched a certain thing. The problem is there is absolutely no standard, national, international, or otherwise, as to what constitutes a match between two fingerprints. It is, like even licensed polyography, completely up to the interpretation of the individual fingerprint artist. Like polyography, most jurisdictions do not license people who give expert testimony on fingerprint evidence. It is based upon the individual interpreter's understanding of how human fingers are shaped, of the shapes of ridges, of the issues of depth, of fat content and sweat content in the hands. It's all just as subjective as the interpretation of polyography. However, fingerprint evidence is allowed into court without people questioning it for the most part. This goes also for several other types of evidence that in 2010, the National Association of Criminal Defense Lawyers released a report that said most forms of forensic evidence that are used in criminal prosecution in particular fall into this category of purely interpretive junk science. Now, whether that you may argue all of that sort of science should be thrown out in court, but you're going to be throwing out a lot more than polyography. And the thing is, you can't distinguish polyography from fingerprint analysis. I'll talk about tire tracks, bullet striations. At this point, it's all should be up to a trier of fact to decide, and they should get all the evidence.
Okay. Certainly. I think that claim that you can't distinguish between a polygraph and other types of evidence because there's a degree to which they are imperfect is something that I think overinflates the reliability of the polygraph test. So I agree with the claims that you're making insofar as that no science is ever entirely perfect, insofar as that obviously when you're gathering evidence from a crime scene, that's a lot different from gathering evidence in a scientifically rigorous context like a lab or something, which means obviously there are always going to be impurities that exist in there. It seems like a fairly intuitive claim, though, to say that the goal of evidence providing in court and the goal of the standard that we hold it to should try to be the best possible evidence that we can provide. And we should actively try to work away from things that muddy that understanding of truth. So, yes, while it's true the fact that, fingerprints are not always 100% reliable, and then perhaps that takes into account the fact that that is also something that we should not be holding like overall 100% sway into. And that if someone, is being convicted purely on the basis of a fingerprint evidence, that's something that we should call into doubt, right? But there are plenty of other other forms of science and forensic evidence that are used that just are far better than the polygraph test, insofar as that fingerprints, as you pointed out, do have some imperfections in them, but are still, pretty reliable most of the time in terms of dictating who it was. That, DNA evidence is something that has a very strong correlation in terms of being able to identify what particular samples or what particular people were found in those particular areas. The problem of the polygraph test is that it presents itself as being, so when I make the claim that, it's pseudoscience, I'm not making a claim that it's something that has a measurement that is interpretive or imperfect or anything like that. I'm saying that quite literally, it does not prove what it sets out to prove. And the problem specifically about the polygraph test is that we have such a culturally ingrained idea about it being an infallible lie detector machine, right? As if you notice that, like, the topic of this very debate is about lie detection, right? Which means that even if you have a certified expert there saying that, oh, well, all of this thing that tests is like sweat and all of these other sort of factors, that it's very easy for a defense or any other kind of case to push this particular narrative on a jury and convince someone that this, in fact, is indicative of a lie that someone is producing. And the problem with that is that, as your claim, that we should put all of the information on the table and just let the fact-finding process dictate what is the truth there that can then lead to a conviction. That when you have a piece of evidence that actively misleads and disrupts and corrupts the process of fact-finding, that ought to be something that be discounted from that process.
All right. Well, now I want to get into two very kind of legalese elements, and I hope you will indulge me because law is my background. There are two issues here. First is a distinction between the kind of evidence that we consider so unreliable that we keep it out altogether versus the kind of evidence that we rely on a jury to sort out and on lawyers to call into question. The second has to do with what purpose certain evidence is admissible for. Addressing the first, everything you're saying about the weaknesses of polygraph tests as a science, everything I've said about the weaknesses of other forms of science as evidence, that all goes to what we as lawyers call the weight of evidence and not the admissibility of evidence. There's a very big difference between saying a jury should not be told X is absolute proof of Y. That is a central tenet of both of our legal systems. You can't just say to a jury X is proof of Y. You're going to get called out on it by the other side. You might get called down on it by the judge. It might even be unethical in certain circumstances, especially if you're saying it as a criminal prosecutor. Second, there's the issue of what can you use certain evidence for. You say the polygraph does not prove what it sets out to prove, and I believe what you mean is that a polygraph cannot scientifically say with beyond a reasonable doubt that one person is lying or not lying. The thing is, in both of our legal systems, you can't introduce that evidence out of nowhere anyway. That's called bolstering. You are not allowed in either of our legal systems to introduce evidence that says, my guy said X, he took a polygraph X test and X is the truth. What you can do, and what especially criminal defendants should be allowed to do, is when a witness has been specifically basically called a liar by the other side, you are permitted to come back with, no, here is evidence that refutes your allegation that there was a motive to lie. That is something the polygraph can be used for. So we have other controls for the concerns that you're bringing up beyond just ban the polygraph. First of all, we have constitutional controls. The police shouldn't be able to use the polygraph to provide evidence that a criminal defendant is lying, but that's a matter of a person's right not to be forced to testify against themselves. It's not a matter of keeping out the polygraph. It's a matter of constitutional rights. A polygraph shouldn't be able to be thrown in out of nowhere to say this witness is better than witness X is better than witness Y. You already can't do that. That's illegal bolstering. So what we've got to get down to is, how are you going to say we can't let polygraph evidence in when we let in all these other types of science that are just as subjective and that have no more concrete basis either in reality or in a lab tested?
So I'm just going to dispute this claim that these other types of science are just as subjective. I think that polygraphs absolutely fall into their own category of being something that it greatly varies depend on context and its ability to actually prove anything close to what it's setting out to prove. So I think it's interesting that you note that there are a bunch of instances in which the polygraph would just straight up be inadmissible insofar as that it would, if it's bolstering, as you put it, or on other stages of the case. The one example that you did provide where it would be admissible is that if someone calls out a witness in terms of being a liar, that you could get them to take a polygraph test and sort of dispute that claim as it is. The problem with that is that, once again, unlike fingerprint evidence or unlike DNA evidence or a variety of the other things that we provide, is that the accuracy of this polygraph test like vastly changes on context, right? So if someone, for example, says that makes a claim about a particular person that, they were there, they handled this particular object, right? And then you dusted that object for all the fingerprints that were on there and that their fingerprints weren't on there. That would be a similar, proof of claim that what that claim is false. If it's the case that someone just accuses someone of lying and then they put them on a polygraph test, then that presents a whole number of other issues insofar as that, like, if I'm a person in court, right, and I've just been asked to give testimony, and then in front of a whole bunch of people, I've been called up and said, you're a liar, you're trying to defend this person of, whatever, and then you put me on a polygraph test, I'm probably going to fuck it up. I'm probably going to read that, of all the kind of indicators that I am in fact lying, because I've just been called a liar in a criminal, prosecution setting, which is a very nerve-wracking experience. So the inherent problem of the polygraph test is that when I say it's subjective, it's not that the data that is interpreted of it is subjective. It's that the actual measurements change depending on the context. And that, if we're trying to create a sort of spectrum of perfect scientific, infallibility versus something that doesn't actually prove anything, surely something that can have such a wide range of readouts and different data that it provides to you, it sits right down this end of the context where it says that this isn't something that can be legally accepted within that context, because it's something that can just spur of the moment prove, in fact, the exact opposite of the thing that you are trying to prove, because just based on that person's individual context and how they're feeling at the time can vastly change what the readout of that particular test is.
All right, so you've kicked it back to me. Let me first head back to fingerprint evidence, because we're stuck on this same prospect, the idea that fingerprint evidence can prove something that a polygraph can't, that fingerprint evidence can prove this is X person's fingerprints better than polygraphs can prove it's X person is lying or not lying. Fingerprints are every bit as subjective, and this is a very difficult concept for people outside the forensic community to understand. The best match that you have among fingerprints is a 10-point match. If you got 10 indicators that someone was or wasn't lying on a polygraph, you'd be doing better than the vast majority of exams. The vast majority of fingerprint evidence that's admissible relies on way fewer than a 10-point identification. But that's the whole point. You can put that flawed identification of a fingerprint in front of a jury, and it's the other side's job to show the jury, here is the reason why you might not want to believe that this fingerprint analysis is what it says it is. But you can do the exact same thing with a polygraph test. In fact, the mass skepticism of the polygraph test that has existed since the polygraph's inception has not existed for most of the time that we've been using fingerprint evidence, the past century and a half or so. So in fact, the polygraph is a more reliable piece of in-court evidence insofar as there is more literature, there are more expert witnesses to be called, there are more analyses and studies out there that you can present to a jury or to a fact-finding judge to say, here is why you can or cannot rely on this polygraph test to prove what it says it proves. That doesn't exist for the vast majority of forensic science used. Now, I want to bring back specifically DNA. You pointed out that the thing DNA can prove is that person X was in place Y. We have run into the problem with DNA at this point that assertion that the DNA proves X was at place Y, even at time Z, is somehow sufficient for criminal conviction when it is anything but.
All right. So it appears that Tom's having a couple of issues with his connection. Hopefully he'll be able to get jump back in. But just in the interest of continuing to have something interesting to listen to, I'm just going to kind of keep delivering a couple of points. So I think that the difference between, as Tom was providing, the idea of DNA evidence and fingerprinting and stuff like that, is that yes, it's true that there's that the evidence that has been provided there is imperfect, that it doesn't directly support without a shadow of a doubt any amount of claim that is particularly being provided. The main comparison that I want to try to just hammer home throughout this video is that all of that the basis that Tom is relying on to prove that the polygraph is comparable to these other sorts of things is saying that, look, these other sorts of evidence have a narrow scope. They have limits on what they are able, on the data that they're able to collect, and thus what they're able to prove. And so that is true both for the polygraph and for all of these other sort of pieces of evidence. The main claim and the main comparison I want to try to make. Oh, you still there? Can you hear me? Yeah, sorry, you were out for just a second there. So just to reiterate some of the stuff, are you able to hear me? Are you all right? Back in? Okay, fantastic. So the claim that I just want to sort of dispute is that it seems that the comparison that you're making to other forms of evidence and the polygraph test is that there are limits in terms of what they are able to prove, like the kind of scope of the data that they are able to collect, and that also has natural limits in terms of what that is able to prove in terms of supporting a particular legal case, insofar as that, fingerprints can only prove, what the amount of like lines and ridges and points and fact content. DNA can only prove specific matches between specific samples, and then that is inadequate to be able to prove something within a broader criminal context. I want to move away from that comparison for a moment, because as you said, that is true for all parts of evidence that we admit into court. The main distinction between a DNA test or a fingerprint test or any of these things and a polygraph test is that it's much clearer that what they are testing is able to be interpreted reasonably by a jury or by a judge, insofar as that it's very clear when you say, that this person has a likely match of a fingerprint or this person has a likely match of the DNA, that the kinds of things that is trying to prove is much closer than saying that this person had this particular readout on a polygraph machine, which, based on someone's ability to interpret that information, can just prove something completely different from what it's actually being shown, and that is the salient problem that exists.
And that's a problem that I've already addressed earlier, which is what can you use the polygraph evidence for? What can you use it to prove? Something that we have in law is what are you offering evidence X to prove? For instance, there is a category of evidence that is broadly considered unreliable and inadmissible in court to prove what it says it proves, which is hearsay. Hearsay is a statement by a person not testifying in court offered to prove the truth of the matter asserted. However, a statement that would be hearsay if you were offering it to prove what it said. All right, Jill said the car was red. Okay, you could not have Bill say Jill said that the car was red to prove that the car was red. You could use it to prove that Jill was lying because Jill earlier testified that the car was green. You could use it to prove that Jill was colorblind because some other scientific tests showed, no, wait, the car was actually blue, and for some reason Jill perceived it as red. So when you're talking about polygraph versus fingerprint, actually the very thing that you were trying to use to bolster other forms of pseudoscience over polygraph is exactly the danger of those forms of pseudoscience, which is that fingerprints are offered to prove fingerprint X belongs to person Y, when in fact, in the court context, there's not a great deal of uniformity. There's not a great deal of literature. There is not a great deal of anything outside of one fingerprint analyst's opinion that you can offer to a fact finder in order to back up that fact. Someone points out in the comments, points to what appears to be a National Institute of Health study regarding fingerprints. Well, there you're talking about the rigors of the science applied at the National Institute of Health level, trying to determine a much more discrete set of facts. In the context of court, you're trying to determine a great number of facts to get to one central point. And this is what I want to close with. We talked earlier, we could be talking about the civil system, we could be talking about the criminal system, we could be talking about administrative systems. At the end of the day, polygraphs are not just being used, and neither is any other science, to litigate the question of, is this person telling the truth about fact X? It is a totality of evidence that a trier of fact has to put together like a giant mosaic to determine a greater truth. In our shared system, we trust the trier of fact to sort through the gunk, even when we've got issues with the gunk, and we trust the lawyers to point out the problems with the gunk, not some sort of blanket ban on one discrete form of science.
Okay, certainly. Look, I think that ultimately the sort of broader claim that you're making here about the role of the legal system is that basically that as much evidence as possible within any sort of context is something that should be provided, and that we should just support the capacity for whether it be the jury or the judge to rake through all of that and try to determine the truth from there. The comparison that I'd like to make as grounds for why polygraphs specifically should be excluded from this process is because, as you say, that there are certain types of evidence that are inadmissible, like hearsay and other kinds of evidence like that. And I would point to the main reason, or one of the reasons why those particular evidence are excluded from a case is on the basis of them being quite misleading, right? I would say that in many cases that the reason why, as a legal system, or just, even if this isn't the way that it currently works, the way that it ought work, is that if you have a piece of evidence that is likely to lead a jury or a judge towards a conclusion that is not the conclusion of the truth, then that is something that should be actively disbarred from the legal process, right? So if it's the case where, you have some particular hearsay evidence of someone who knew that they said something that is no way verifiable, or has not taken any kind of oath or anything like that, then that is something that we would like to throw out, because even if it's the case that might sound very compelling to a jury, we wouldn't wish to mislead them in a particular way. And there are a number of other ways that we try to make sure that the jurors understanding of the court case is something that is as objective as possible when we do things like, bar them from interacting with certain media outlets or processing other kind of information like that might bias their outlook for it. The case that I'm making for the polygraph machine is that instead of being something that is just, an imperfect piece of data that needs to be interpreted through various ways, that it actively goes against the goals of the legal system in terms of determining truth within the context of a case. Not only because it's very specifically doesn't prove what it sets out to prove, it proves a bunch of random information that can vastly change depending on court context. That just, if you're nervous from being in court, that is the same as whether or not you are lying, and that poses a very big problem when it is indistinguishable about what those two things are. And that itself is grounds about why we should disallow it from court, and why we should make sure that we only allow evidence that better helps whatever the fact finders within that system to move towards the truth. But thank you very much for this debate. I think that we both had a couple of interesting points. And best of luck for future competitions. It's been a pleasure.